Good morning. We are very happy to welcome you all on Cobalt Pan-Baltic webinar on unfair trade practices. We are very privileged to have also enforcement authorities with us. So we are extremely happy to welcome to the webinar also Svetlana Sitnikova and Cynthia Nagle from Latvian Competition Council and Katrin Tasa from Estonian Competition Authority. As always, I'm really pleased to present this topic together with my fellow competition and EU partners from Cobalt, Rasa Zaščurinskaite from Cobalt Vilnius and Udis Želtins from Cobalt Riga. Before we go on with the presentations, let me say a few words about the topic of the webinar. The discussion of the functioning of the food supply chain has been going on in EU already for quite some time. The Commission has many times suggested various voluntary means for the food and food supply chain to tackle their unfair practices. Many countries have in fact had their own rules on unfair trade practices. It includes Latvia and Lithuania. In Estonia, we have so far looked at those supply chain rules with a little bit of skepticism, but here we are. Now we also have to regulate it. So the European Commission, when viewing those unfair trade practices, they realized that this needs a directive. So in 2019, Directive on Unfair Trade Practices in business-to-business relationship in the agriculture and food supply chain was adopted. The number of this directive is 2009/633. The transposition deadline was 1st of May this year, and the requirement was that the new rules need to enter into force as of 1st of November. So here we are, all Baltic countries have transposed the rules, and this is the time to discuss the new rules. Let me display the agenda of our day. We will have 1.5 hours max. We may start a little earlier if there are no questions. I doubt that. I invite everybody to post their questions actively. Our aim is to give a comparative overview. It will be 3 countries, so we will not have a chance to go into depth with all of the practices, but we will try to make a comparison of the countries. So as the first presentation, Cobalt will present you the comparison of the implementing measures. Next, we will have Latvia's Competition Council, senior expert Svetlana Sitnikova and senior lawyer Cynthia Nagle presenting the enforcement experience and their view of the trading practices and prohibition acts. And then we will have comments from Estonia by Katrin Tasa, the deputy head of supervisory department of the Estonian Competition Authority. Please post your questions. The comments or the questions box should be well visible to you. We will take the questions after the presentation. And in case you wish to address a specific question to a specific person, please state it so. Then it will be easier for us to allocate the questions to the right persons. So without further ado, let us start with the introduction of the implementing measures of the UTP directive in the Baltics. So this is a new abbreviation to remember, unfair trade practices, UTP. And let me ask my colleagues Rasa and Udis to join me in presenting the Pan-Baltic view. So our thoughts was that we will do a comparative view. So it means that we will discuss as one voice, but bring out the differences for each country. So which products are we talking about first? It is agricultural products, it's food products. If it's food, then it is covered. if it's an agricultural origin product, we have to look at the list of which is annexed to the Treaty on the Functioning of the EU. And here on the slide, you just see a few of those products which are covered. So we ask you to consult the list very thoroughly, because it is just really a lot of different products that we are not able to cover. But it is agricultural origin, it's animal origin, meat, fish, and specific other products, including, for instance, also alcohol. And this is where I would want to ask my colleague Uudis Želtins to explain, because there is a difference in Latvia in comparison with Estonia and Lithuania. So Uudis, please.
Good morning, Elon. Thank you for the introduction. Indeed, the definition of food and agriculture products in the law, in the implementing law in Latvia, has been supplemented with a few additional words. And the definition also encompasses water, including mineral water, and non-alcoholic drinks. That is the only difference in terms of definition of food and agri products that we have in Latvia.
Rasa, is there anything to add, or we can move on to the next slide?
Hello, everyone. Thank you. Hello. Yes, just a small remark from Vilnius and from Lithuania. We have a separate law which regulates the behavior of major retailers. I will briefly touch upon this law later on. But just as this law also mirrors to a certain extent the prohibitions under the new law, the products covered by this specific law also includes the drinks. So under the new law, the drinks are not included, like non-alcoholic drinks, only the food, but under this specific law, the drinks are included.
Okay, great. Let's move on. So who is affected? When we know what the products are, we need to know who are affected. And let me again start by Estonia, because in Estonia we have taken a simplistic view, which actually goes a little bit beyond what the directive allows. In Estonia, all buyers and sellers of agricultural food products are covered when they are established or reside in EU. There is only one exclusion, is the consumers are excluded as the buyers. But there are no turnover thresholds in Estonia. There are no exemptions. It doesn't make any difference on how large the seller and the buyer of these food and agriculture products are. So in this way, Estonian rules are quite clear, but it also imposes quite a wide obligation to all different sellers and buyers. So it would be good. The situation here is different per each country. So, Uudis, can you explain the Latvian rules?
Indeed. In Latvia, the law covers all suppliers, regardless of how large they are. Even the largest of corporations will be protected under the new rules. The directive does not call for that. The directive permits the solution for which the Latvian legislature has opted, but does not call for. In that regard, the scope of protection required by the directive has been enlarged in Latvia. Now, let's talk in a few words about the persons upon whom the obligations are incumbent, i.e. the buyers. The Latvian law now says that all buyers with annual turnover above 2 million euros are bound by the new rules. In this regard, the new regime under the law which entered into force on 1st of November has reduced red tape upon small retailers. The previous regime on bargaining power applicable to retailers applied to all food retailers. Now, only those whose annual turnover exceeds 2 million.
Rasa?
Yes, so in Lithuania we have a bit more complicated scenario. We have some exceptions. So we have certain thresholds. In general, buyers and sellers of agriculture and food products who are established or who reside in the European Union are covered by this new law. However, the suppliers of agricultural food products with an annual turnover of more than 350 million euros are excluded from this law, as well as small buyers with a turnover which does not exceed 2 million euros will not be subject to the rules under the green and blacklisted practices, which we will cover later on. As well as agreements with the consumers and agreements with the cooperative societies and small partnerships or their members are excluded from this law. In addition to that, we have additional thresholds, supplier buyer turnover ratios when we talk about the grey list and blacklist when they apply. I will not go into detail into those very complicated rules, but just an example to illustrate those thresholds. So in case the buyer's turnover is above 50 million euros, the blacklisted and grey listed practices will apply in relation to the suppliers whose turnover is below 50 million euros. So both the suppliers and the buyers should do very careful homework in deciding with which counterparties the new law will apply.
Thank you. So looks like there is quite a little bit of deviation here between the countries, and let's see what it means. But now to go on to when we know what the products are, who covered are, then each of the laws that implement the directive, they list prohibited unfair practices, which is a blacklist. And later on, we will also talk about conditionally permitted practices, which is a grey list. But first of all, we will have 3 slides of the prohibited unfair practices. And we have tried to identify what is the coverage across the Baltics, which types of practices are then prohibited in each of the countries. And you will see that there is some variation. We will have 3 slides on it. We have simplified those kind of descriptions of the practices a bit because it would be very difficult to make a comparison if we would be very exact on it. Let me start for Estonia. Estonia has implemented quite a minimum list of unfair practices. Perhaps one of the differences in Estonia is that there is no difference between perishable and non-perishable products. So the explanatory note just explained that it will be difficult to understand when the product is perishable as opposed to other. So Estonia took the approach that all products are covered similarly with regard to these unfair practices. I will not start reading out the list. You have it in front of it. So let us go through again some specific remarks on the countries. And let me ask Rasa to go first, because we know that the situation is different in Lithuania. We also have quite a few of asterisks in some of the places. Maybe the special cases are more to the next slides, but perhaps you can start with this slide, and then Uudis can take on with the first slide as well.
Well, thank you, Elo. Yes, we have our certain peculiarities in regards of the products to which will apply. In certain cases, there are differences what the status of the buy is. I would not like to go into very detail this sunny Friday, at least in Vilnius, but I will have some more comments regarding some peculiarities on the other slides once Uudis will add his comments regarding this slide.
Well, indeed, the Latvian blacklist is longer than that required by the directive. And in some respects, further details are added. We do distinguish between perishable and non-perishable products. Also, in the Latvian implementing law, there's a special provision concerning fresh vegetables and berries that are delivered to a store at least 3 times a week, when even shorter maximum payment period applies, unless the parties have agreed in writing to default to the 30-day rule. Any trader engaged in transactions with agri-food products is indeed required to pay quite close attention to the specific national rules and also to Latvian Competition Council's very helpful guidance. As of today, it has been published in draft form, the authority having invited interested parties to submit comments, but they help a great deal to understand the minute details behind all of the individual prohibitions.
Thank you. Udis, perhaps you can go on with the next slide as well, because for Estonia, again, there is this is the minimum list that we have, and there is nothing to comment from Estonian perspective.
Indeed, as I noted, the Latvian list, the Latvian blacklist is longer than that in Estonia and than that required by the directive, and this is largely a heritage of the earlier draft on prohibit unfair retail practices that existed until 1st of November and applied only in the relationships with retailers. For example, we have provision that is a blanket prohibition of unfair sanctions. We have a separate provision for that. We also prohibit the imposition of most favored customer clauses. Just to name a few examples. I may also add that, for example, we have a special rule which prohibits the buyer to accept products with less than 2/3 of shelf life remaining, where the shelf life exceeds 30 days. The Latvian legislature and the Latvian industry have been discussing those issues for years now. And our relatively long list of prohibitions is a reflection of that.
Rasa?
Okay, if I may, yes. So we, as I mentioned before, we have a separate law which applies to major retailers, and under this law, which still exists and still will apply in relationship between the sellers and those 5 major retailers, there are additional blacklist listed practices which are prohibited to be taken by the major retailers. Some of them are the same or very similar to the ones Ugis mentioned from the Latvian perspective. So, such as most favored customer clause on the seller. As well, we have prohibition for the buyer to request the seller entry fees, stocking listing fees. As well, there are other prohibitions applicable to major retailers, such as request the seller to compensate lawyer profits, both directly or indirectly. E.g., for instance, in case the products are not sold and the buyer intends to sell it for a lower price, the buyer cannot, such retailer cannot request the seller to compensate such ungained profits. Also, it is prohibited to charge the seller for the renewal or installation of the shops, request the seller to acquire products, services, or assets from third parties, and the one additional is the buyer changes the essential supply procedures or product specification without due notice. So these additional blacklisted practices under the specific law, which are applicable and protects the suppliers as well.
Thank you. So we are done with the blacklist and we move on to the grey list, which is the unfair practices which are prohibited in case they have not been agreed between the parties in advance in writing. So there are most probably in each of the countries a specific exactly how this needs to be agreed in writing, but the general trait is that it needs to be an advance written advance agreement. And now I can say that there is also one specifics for Estonia. In general, we are following the same list that is in the directive. But one of the practices has been included in the grey list for Estonia, which doesn't, which is unique for Estonia, and it is prohibited for the buyer of the food and agricultural products to require the seller to use only a certain type, shape, and size of packaging, transport packaging, in case it has not been agreed in advance. So there was quite a lot of discussion about this type because it has appeared that the retailers have wished to kind of unify the transport packaging for quite some time. And there has been opposition from the suppliers to that. And for the protection of those suppliers, the legislator decided to include this, practice also to Estonia. But perhaps now going forward, Lithuanian list is quite similar to Estonian, so perhaps Rasa, you can comment next, and then Udis, because Latvia stands out here a bit.
Yes, just very brief comment from Lithuanian side, as we more or less transposed what is under the directive into the new law. Again, what is very necessary to emphasize and what we see from the previous case law of the Competition Council in terms of implementing the law applicable to the major retailers, it should be very clearly in an ambiguously agreed between the parties in order to have this grey list practice not to be applicable. So it's not only in advance in the written form, but also very clear agreement what the seller agrees and what conditions will apply. Otherwise, in case at least a certain part is escaped and not agreed between the parties in writing in advance, the authorities would most likely regard those as not complying with the law, and then the prohibition would apply.
And in Latvia, let me note that the absence of tick marks in our table does not mean that we have nothing to say about those specific practices. We deal with some of them under the blacklist with certain caveats and exceptions for sure, but Latvia has also moved the grey list items, several grey list items, to the blacklist. As Rasa noted, according to our Competition Council in Latvia as well, it seems that when it comes to the grey list, clarity and transparency is key. That is stated very clearly in the draft guidelines. As to the form of the written agreement, which is necessary for the blacklisted practices to be permitted, I am very happy to read in authorities' draft guidelines that email correspondence seems to be sufficient. Thanks.
But perhaps with this you can go on with the non-food products. Now we have some specifics for Latvia and then also for Lithuania. We are running a little bit of behind the time, but not that much. So go forward.
Right, indeed, Elo. The Latvian law also carries over from the previous regime without any major changes. The obligations that are imposed on certain non-food retailers, and those are the largest retailers who do have bargaining power vis-a-vis their suppliers. The definition of those retailers who have that bargaining power is rather complicated. Lots of qualifying features in that definition. You see them listed on the slide. The central idea being that the retailer has appreciably more bargaining power than the supplier at issue. When it comes to those sorts of relationships between a strong non-food retailer and a less strong supplier, what you have to bear in mind is that there is a list of 6 blacklisted practices. They deal with payments for processing of agreements, payments for stocking, shelf payments, etc., contributions to the costs of opening of a new store. There are certain restrictions on return of goods, unfair penalties, and long delays in payment.
Okay, then also Lithuania. Okay, now what needs to be done is to have the to take into account that the transposition measures are already entering into force. There is a small deadline for bringing agreements into compliance. You will see them. And why it needs to be done, perhaps we will not go into very much detail, so we can share the slides afterwards, but there are consequences. In Estonia, the prohibited practices avoid. There are also various coercive measures and really high fines in each of the countries which are foreseen. And there is also some additional obligations on the major retailers in Lithuania. So Rasa, maybe you can take this forward.
Yes, just very briefly, as I mentioned before, we have a separate law which applies to major retailers, which are 5 at the moment. You can see them on the slide. And this law establishes the blacklist and grey list practices since 2010. So we have already the practice. We know how to apply at least certain of the grey list and blacklist prohibitions under the new law as well. However, this law is supervised by Lithuanian Competition Authority, both in regard this law, also in regard of the new law implementing the directive. In respect of other other suppliers and retailers to whom this specific law does not apply, we have a separate authority, the agency, which supervises the implementation of the law. Without going into detail about the differences of this law, just very brief note that to the major retailers, both the new law and the specific law will apply, and in case by the same actions infringement is made, so the specific law, the retailer's law, let's say so, will supersede, will apply. And just a very short note on the major change in regard of this law, which happened together with the adoption of the new law, was that the protection of the suppliers extended in terms of turnover until November 1st. It was suppliers up to 40 million euros to whom the protection would apply under this law. And since November, it's all the suppliers, not only of food drinks, but also agriculture products with a turnover of more than 350 million euros. Just a small note, turnover shall be taken into account together with the group companies turnover.
Rasa, I understand that there have been also recently some fines on those practices. Maybe you can touch upon them right now.
Yes, very briefly, we have a rather active competition authority in implementing and supervising the specific law, the retailers law. And at least one or two decisions of the authority is adopted within the year. And last year there was a decision of the authority where it imposed the fine to one of the major retailer, Link, of 78,000 euros. The infringement was then the retailer required suppliers to use the marketing budget, which was specified only as a preliminary, and it was not agreed very clearly what the supplier should be paying for. The interesting note regarding this case is that the main evidence we gathered during the town raid performed by the National Competition Authority, and the emails were the core evidence of the authority to find the infringement and to impose the fine. And I think we can finalize with the practice. We can go on, but as we are running out of time, so I think we could stop here.
Absolutely. So basically what needs to be checked and done is that you need to check which relevant law is applicable. You may be subject to a grey list and a black list, and it might be different when you are buying or selling. So these are the recommendations that you have. Check your agreements, make checklists to be sure what kind of practices are fine, and double check and prepare the checklist constantly. So some of the, I hope we have been able to cover just very briefly on what the differences are. It's clear we will not be able to respond to all your questions or kind of to be able to anticipate your questions. So please put forward your questions that you have and we will try to tackle them then later on. Thank you very much from Cobalt. We will end it from our side for a moment. We will give it over to the enforcement agencies. And first of all, to Latvia, please, Svetlana Sitnikova and Sitnia Nagla, the floor is yours.
Dear ladies and gentlemen, dear colleagues, it is my pleasure to see you all today in this in Latvia. It is a snowy day today. My colleague, Cynthia Nagla, the senior lawyer, and me, Svetlana Sitnikova, senior expert in the Competition Council for the Republic of Latvia, will present to you the presentation of Unfair Trading Practice Prohibition Law, the national regulation of the UTP directive in Latvia. And the purpose of our today's presentation is not to name the unfair trading practices that was already done just some minutes ago, but rather to address an interpretation and explanation of some nuances of the national law. And the milestones for the Competition Council of the Republic of Latvia on the UTP directive somewhat different from the key events that took place since 17th of April 2019 when the UTP directive was adopted, and the 25th of April when the final act was published in the official journal. The Competition Council started to work on the directive since the 12th of April, and this is then the competition submitted to the Council and the European Parliament the legislative proposal of the directive on unfair trading practices in business-to-business relationship in the food supply chain. The Competition Council cooperated with the Ministry of Agriculture of the Republic of Latvia in this respect. And we cooperated with the Council's linguist lawyers from the very beginning, and there are no surprises for us as to the wrong terminology used in the final act to be transposed to the national legislation. And on the 7th of April this year, SAIMA, or the Parliament of Latvia, adopted the Prohibition on Unfair Trading Practice law. And on 20th of April, the law was published in the official journal, Latvijas Vēstnesis. At the moment, the translation of the national UTP law is available in English, and there is a link in the slide to this translation. What we would like to remind and say to the operators on the market is that supply agreements that you should remember about several dates on your agenda. This is the 1st of November, and this is next year's April. And why that? It is because the supply agreements that are concluded after the date of publication of the national UTP law, this is after the 20th of April, should be brought into compliance with this law until the law comes into force. This is until the 1st of November 2021, until this year's November. On its turn, supply agreements that are concluded before the date of publication of the national law, this is before the 20th of April 2021, should be brought into compliance with the new law until the next year's 20th of April. So 20th of April 2022, this is the date to remember to everybody. And as compared to the UTP directive, the National Unfair Trading Practice Prohibition Law is a little bit different. UTP directive contains the definition or the UTPs and a minimum list of prohibited UTPs, and so-called 10 black practices and so-called 6 gray list practices, and 10 black list practices are the practices that are prohibited in any circumstances. What concerns to the gray list practices, these are the practices that are prohibited unless the parties clearly agree and agree in an unambiguous manner on these practices. In this case, the practice would be allowed. And in the national UTP law, there is a general clause as well. In the national UTP law, the general clause is defined as the unfair trade practice as actions which conflict with fair trading practices and do not conform to the requirements of good faith and fair dealing. A policy maker, in this case it is the Ministry of Agriculture of the Republic of Latvia, included the general clause in the provisions of the national UTP law for purpose to prevent the agricultural and food supply chain operators using of unfair trading practices in their comparison. So this is, this is done on purpose. And in addition to the general clause, the national UTP law contains 16 blacklist practices, and 5 gray list practices as the provisions that, as well as provisions that regulate payment terms between the trading parties. And on the top of that, there are 6 prohibited practices for non-food products, and these are included from the previous national UTP law. This is from the unfair retail trade practice prohibition law that was in Latvia from the 1st of January 2016. This was already mentioned here, and this law regulated relationship of suppliers and retailers only of food and non-food products. And yeah, I would like to mention here one more time what colleagues from Cobalt already told is about the guidelines for the national UTP law to help operators to apply the law, as the law is quite new, and some practices are absolutely new, and they are not applied from the previous regulation. The Competition Council published for the social consultation process the draft guidelines, and at the moment the consultation process is finalized, and at the moment we are working on the comments that we received from the operators, from associations, and from the companies. And as soon as the guidelines will be finalized, they will be published on the website of the Competition Council, and we will announce on our social media as well, that and social media accounts as well, that the guidelines are published. In addition to what I told, you can follow the information that we published on the website of the Competition Council regarding these new provisions and the new unfair trading practice prohibition law. I would like to say, maybe repeating already previous presentation, but anyway, to remind one more time that the national law protects a wider range of operators in the food supply chain, or expand the range of agricultural food product suppliers protected from unfair trade practices. This is because the prohibition on unfair trading practice law applies to all operators of the agricultural and food supply chain, retailers, food processors, wholesalers, cooperatives, producer organizations, and individual producers, as well as to the public buyers of agricultural and food products. And suppliers of food products as well as buyers can be both natural and legal persons. So this is one of the differences from the previous law, and probably you should pay attention to that. So in addition, some of the provisions of the UTP law apply only to the retailer of agricultural and food products. As opposed to just supplier of agricultural and food products or supplier. And it should be emphasized as well that the same operator in the agricultural food supply chain can be both the buyer and the supplier, depending on the cooperation and depending on which side of the buying or selling process it is engaged at the moment. So I am giving floor to my colleague, Cynthia. Cynthia, please.
Thank you, Svetlana. Hello, everyone. I will continue and I will give you an insight into written justification for requested payments and liability for violations of national UTP law. So Section 5 states that buyers are prohibited from actions which conflict with fair trading practice and do not conform to the requirements of good faith and fair dealing. That includes the obligation for the buyer to provide to the supplier a clear and traceable written justification for the total requested payment or payment per unit for products being present at a sales location, discount or campaign discount, as well as advertising, marketing, and logistical service. In addition, in case of payments for the advertising, marketing, or logistical service, the buyer is obligated to provide an estimate with objective and traceable costs and justification at the request of the supplier. Besides, national UTP law does not prohibit to provide such information without supplier's request. And also, it is necessary to specify that there is a difference between products in shelves of the sales location and products in special places. Section 5, Part 1, Point 2C applies that to the case when the buyer and the supplier have entered into a written agreement and that it will be paid for additional arrangement of the products in special places. So based on a written agreement, it is permissible to charge a payment only for the placement of products in special places, but not for the products in shelves. So for the sake of clarity, product placement in special places include all kinds of additional arrangements in particular sales location, like, for example, additional stands, pallets, baskets, end shelves, etc., all of which are considered to be additional arrangements. So regarding discounts, for example, bulk discount, which is a discount that is applied depending on the volume of the products ordered, or a campaign discount, which is a discount that is applied for a limited and specified period of time to promote the sale of products, it is necessary to agree beforehand in written agreement on the expected quantity of products to be supplied at a discount, and the requested payment must be justified in writing. So it's important that the supplier receives a clear and traceable written justification, and depending on the provided justification's detailization level, it can be for the total payment or payment per unit. For example, when written justification for the total payment does not always reveal the exact cost item that would allow the supplier to verify that the payment is justified. Also, buyers consider not only the transportation of goods as logistical services, but also, for example, the assembly of goods, preparation of documents accompanying the goods, and printing, and something else, whatever it is necessary. And accordingly, when applying the fee for issuing delivery invoice in situations where the exact number of notes issued cannot be predicted, a written justification for the payment per unit will be clear and traceable. So in other cases where the total payment consists of one type of multi-cost item, a written request for each item cost is not requested. For example, in the case of a payment for outdoor advertising, presuming that it is known how many identical billboards it will be placed on, the provision of information on the total payment may be considered clear and traceable. So to be clear further, I will explain the scope of advertising, marketing, and logistical service. And advertising is in any form or any mode of announcement or endeavor associated with economic or professional activity intended to promote the popularity of or a demand for goods or services. So this is the definition from advertisement law. And advertising includes the placement of information and informative materials on the internet, television, radio, such as like TV, and radio advertising, also outdoor advertising, brochures, posters, etc. And any type of brand promotion activity can also be considered as advertising. But marketing is the development of a strategy that involves bringing a product to market from producer to consumer. Marketing is understood as a set of planned measures: introduction of a product, introduction, price, design, brand, promotion, choice of sales channels until it reaches the consumer in order to achieve the goals set in the target market. And logistical service is defined as a set of activities that includes transportation of agricultural and food products, processing and fulfillment of orders, inventory management and organization of the storage facility, and so on. So now I will try to briefly explain the liability for violations of national UTP law. If the Competition Council establishes violation of national UTP law and activities of a buyer of a retailer of non-food products, it shall take the decision to establish a violation, to impose a legal obligation, and to apply a fine or a warning. The Competition Council is entitled to impose a fine on a retailer of non-food products up to 0.2% of its net turnover for the last reporting year, however not less than 70 euros, and the same is on a buyer, a fine up to 0.2% of its net turnover of the last reporting year, and however not less than 70 euros, or another equally effective penalty. Council, when assessing the circumstances of the violation, the nature of the violation, and the other circumstances which are relevant to the case, is also entitled to replace the decision on a fine with a warning. And given that by national UTP law, the warning shall be published in the same way as council decisions, and thereof will be accessible to everyone. Warning will indicate both the person responsible for the violation and the nature of violation. And sorry, the infringer subject to liability within the meaning of the national UTP law is the buyer and the non-food retailer or association thereof. If the violation of the prohibition of UTP has occurred at the level of an association of buyers and non-food retailers, such as unfair claim arising from cooperation and contractual arrangements between association and its suppliers on behalf of its members, the association is responsible for implementing the prohibited acts. So on the total turnover on all the members of the association. Where the violation of the prohibition of the UTP is the result of the conduct of an individual member, the liability shall lie with the member of the association on the basis of the turnover of that member alone. So in addition, I would note that the Council has the right to impose a legal obligation on the buyer and the retailer of non-food products, which is aimed at preventing the violation, after the decision has been made, because a legal obligation to bring an infringement to an end against a particular supplier or against suppliers in the procurement market prevents the infringement from continuing. And in order for this measure to have a sufficient effect, national UTP law provides that the Council is entitled to impose a pecuniary penalty on the offender for non-compliance with the legal obligation up to 2% of the average daily net turnover during the last reporting year, but not less than 70 euros for each calendar day. So I just tried to really short period of time tell everything that I was planning. So I will give the floor to Svetlana. Thank you.
Since the unfair retail trade prohibition law is not an entirely new phenomenon in Latvia, as you already heard, we would like to share some statistics. Since 2016, when on 1st of January, the unfair retail trade prohibition law came into force, So in 2016 and in 2017, there were the most problematic questions in cooperation between suppliers and retailers that were addressed to the Competition Council of the Republic of Latvia were return of goods, respectively more than 1/3 of all the questions received by us were devoted to it. The second was the payment terms for delivered good, and the third one was unfair, unjustified, or non-contractual payments or discounts. In 2018 and 2019, the questions that were addressed to us were regarding sanctions for the violation of contractual provisions, return of goods, unfair, unjustified, and non-contractual payments or discounts. And in 2020 and in 2021, problems were the return of goods as well as sanctions for the violation of contractual provisions. And these problems apparently relate to the COVID-19 emergency situation in Latvia. And the same problems we identified when we conducted market inquiry on application of unfair retail trade prohibition law during the COVID-19 emergency situation in Latvia. Why we name these practices? Because these practices are still prohibited, but they are prohibited in the whole agricultural and food supply chain, and some of the practices are prohibited as well for the non-food products. And in the last 2 years, I would say that the Competition Council received more and more questions regarding jurisdiction and applicable law or the national regulation of the UTP practices. And therefore, the next slide is devoted to this question. So, to comply with the provisions of the UTP directive that are providing that the directive applies to the sales where either the supplier or the buyer or both are established in the union. So meaning that the supply in the union should be protected not only from the buyer established in the union, but also from the against unfair trading practices by the buyer, which is established outside the union. In addition, the UTP directive provides that supplier established outside the European Union should enjoy the same level of protection against unfair trading practices when they sell their agricultural and food products into the union. In Latvia, the national UTP law applies to the sales transactions in which either the supplier or the buyer are established in Latvia. So what this means? This means that first, the Competition Council as an enforcement authority, then the complaint is addressed to it, shall be competent to act. And the second means that the prohibitions are to be enforced irrespective of the place of the economic activity of the trading parties. So this means that yes, we as the Competition Council should be able to act according to the purposes according to the purposes which were stated in the UTP directive. And let me on this note thank everybody for your attention, and yeah, we are open for the questions and we are open for the communications. So I will give floor to my other colleagues. Thank you very much.
Thank you so much, Svetlana and Cynthia, for your thoughts. Latvian transposition and is the fastest. Everybody needs to be compliant the earliest from the country, so it is really good to get your views across. But now going forward, would also very much like to hear from the comments from Estonian Competition Authority. The Deputy Head of Supervisory Department, Katrin Tasa, is with us. And Katrin, this is an absolutely new thing to us in Estonia. We haven't had those unfair practices rules earlier on. So it would be good to hear the comments, what kind of questions you are already receiving and what kind of initial thoughts you have about the enforcement kind of priorities and practices that you are about to embark on. Katrin, the floor is yours.
Yes, thank you. First of all, I would like to thank you all for Cobalt for organizing this very useful event and also preparing this very comprehensive overview of the UTP laws in different Baltic states. I'm glad to be here today to tell you about our brief experience with the UTP Act. And yes, as you said, is that the unfair trade practices regulation is a new topic for us. And of course, I don't have much to say today. Still, during the 1 month period, when the law has been in force, I would say that the most common question have related to the cross-border conflicts situations, and as it already explained by the Latvian colleagues, this is a case where the seller and buyer are established in a different member states, and UTP laws of both countries are applicable. And the question has been which law is applicable in these cases. As the UTP laws don't have provision that govern the law applicable to the contract, which means that the parties can choose the applicable law, but still supplier can choose which competent authority to turn with a complaint. So in these situations, the best solution could be that both UTP regulations are fulfilled. For example, if the buyer is in Estonia, where the payment period is 30 days in all products, and the supplier is in another member states where the payment period is 60 days, then it is recommended to use the payment period of 30 days. And I understand that this is a very resourceful exercise probably for the undertakings, but at least all the risks are lower than these cases. Another aspect is that in Estonia, we are investigating the unfair trading practices under misdemeanor procedure, and our decisions and orders has a binding force only to the persons who are in the territory of Estonia. So basically, we can effectively investigate the undertakings that are in Estonia. And of course, we have had also questions regarding the definition of agricultural and food products. For example, is cannabis covered with this regulation? And yes, it is covered. And also we have had questions, are cut flowers covered? And this is interesting. I mean, cut flowers are covered, but the cut trees are not covered. So our Christmas trees somehow have escaped from the regulation. And yes, this kind of questions we have had so far, I guess.
Thank you very much. Anything about the enforcement priorities or thoughts about that, or it's still too early?
I think it's too early. We haven't had so many explanations, and yeah, I think it's too early to say anything about it.
Okay, if anybody still has questions, there is time to post your questions and I can take them. But we also have had a few questions in our own practice that we would like to address as we have such good competence enforcers here. And one of the very easy questions, hopefully, is the question about intergroup transactions. Are they covered? Because we are used to dealing with competition law. Usually intragroup transactions are not covered by competition law. In a way, it would make sense for them to not to be covered, because it is what the aim of the law is to protect the weaker supplier against the buyer, stronger buyer. If they are in the same group, then it doesn't make sense to have that protection. But it would be interesting to hear your thoughts about, and since Kantri was just talking, so maybe you can answer first, and then Svetlana or Cynthia, it would be good to hear your comments as well.
Okay, maybe I can answer this question. When answering this question, I would like to say that the purpose of the national UTP law is to prohibit unfair trading practices in the entire supply chain of agricultural and food products, and also to ensure that the buying power of retailers of non-food product is not abused. The national UTP law does not distinguish between the types of enterprises, whether it is a linked enterprise, partner enterprise, or autonomous enterprise. It doesn't matter for the UTP law. So as soon as the unfair trading practice is imposed against supplier, this is against supplier of agricultural and food products, and or a person who sells products to a non-food retailer, then it is the matter of the unfair trade practice prohibition law, I should say.
Katrin, what are your thoughts?
Yes, I agree with Svetlana that also in Estonia the intergroup transactions are covered with the law.
Okay, so it's the supplier will come against its retailer pot and apply for fines. And that seems unlikely. Let's say the enforcement seems unlikely to me, but good to know. Thank you for your answers. Then we have this question that does it matter? Maybe this blacklisted prohibition actually has been included in the contract because the supplier itself has requested it. Then does it make a difference? Because how can you say that the retailer is committing a kind of breach if it is on the request of the supplier? And then going forward, maybe you can also say that what can happen if the buyer would want to change the contract, but the supplier is not ready to do so. So how do you see those situations? Svetlana, maybe you can comment.
Yeah, yes, I can comment regarding the supplier who would like to introduce blacklist practice in the contract with the buyer. Yeah, this situation, well, theoretically, probably it can take place. In practice, I don't. Most probably, most of the suppliers are unlikely to want to have unfair trade practice to be applied against it. However, the buyer is the one under the law, under our national law, which is responsible for the violation of the law. So, despite who is the initiator of the unfair trade practice in the contract, it will be the buyer who would be responsible for that black trade practice. So this is the answer to the first question. And regarding what should the buyer do in the case if the supplier is how to say, by any means would like to put the black list unfair trade practice into the contract. It is just to tell that the buyer cannot do this because it is the buyer who will be responsible for the violation, and just in case of the penalties from the competition council, the penalty should be paid by the buyer, not by the supplier. So they should be recalled every time when the contract is signed. So yeah, of course, parties are free in their contract, but as far as to the prohibitions of the law, both parties should comply with the prohibitions in the law. Thank you.
Katrin, would the answer be different for Estonia?
No, not really. Generally, I agree with the Latvian colleague's answer, but this situation could happen if the buyer and the supplier are in different countries. And as I said, for example, in one country, the payment period is 60 days, and in another country it is 30 days. And when it is 60 days, for example, in supplier countries, and of course the supplier could say that okay, we can agree that this could also, the payment term could also be 60 days. But if the buyer is in Estonia and in our country the act requires 30 days, then I would say that the buyer should also use the Estonian law and say that we should put 30 days into the agreement. Otherwise, it will be problematic for the buyer.
Okay, thank you. Maybe also I will also give a kind of additional view, or maybe there are some thoughts of each of the presenters that you would want to share. I will give this possibility as well, but before that, I would want to ask, still with Latvia and Lithuania, and maybe Rasa can help to cover for Lithuania, is that in Latvia and Lithuania you have these turnover thresholds, and the applicability of these unfair trading rules depends on the turnover thresholds. But how is it assessed? Is the turnover assessed at the time of the conclusion of a long-term supply agreement, or annually, or how would the companies need to kind of assess to be compliant with the rules?
As I read the Lithuanian law, I would interpret it that annually should be assessed, meaning that the turnover of the preceding financial year is assessed during the implementation of the behavior. So I would say you should be careful during the whole contract period. Another thing which should be taken into account, that as I read the law together with the UTP directive, as well as it's directly indicated in the retailers law, this turnover threshold in Lithuania of, let's say, 350 million euros should be calculated together with the linked companies. So you should not forget that you should do exercise not only in terms of the direct supplier or buyer what the turnover is, but you also have to be very careful to calculate the whole group company's turnover and then to decide how to behave.
Maybe we can hear from Latvian side then.
Yes, regarding Latvia, I should say that in the definition of the buyer, it is, among others, it is stipulated that the last financial year turnover should be accessed. So it is the last year turnover. So it is basically very similar to what Russell just a few seconds ago said, that it is the last financial year data that should be accessed. And practically this means that if it is a long-term contract, then the turnover should be accessed yearly for the previous year to understand whether in the next year the buyer is going or not going to apply unfair trade practices. Of course, we hope that despite the turnover, the buyer won't apply those unfair trading practices in cooperation with their suppliers. Thank you.
Okay, it seems like it is everything is either very clear or very not clear, that we are not receiving very many questions from the audience. But I think it has been really useful to go over it in a comparative way. So I would just want to invite you to your kind of last comments, maybe something that you heard throughout the presentations that kind of comes to your mind and you would want to say out. And of course, from enforcement authorities, it would be good to understand what are your steps or your plans that you are going to do with the enforcement of this law. And if I may, can I give a floor first to Cynthia, since she has been not able to answer to the questions so far. So maybe Cynthia, you can start.
Yes, thank you. Actually, the first thing we're planning to do is to release these guidelines after we have covered all the comments, and when we understand what is the maybe the areas that are not clear for the buyers or suppliers or associations, then we will further understand where we will concentrate our focus for the next period of time, like for the 2022. But for now, I can't comment anything detailed about our plans. So maybe my colleague Svetlana would like to add something.
I should join to Cynthia, and I should tell that at the moment, since the law, even if it is the law itself kind of not new for us, for Latvia, anyway, it is important for the market and for some of the agricultural and food supply chain operators, it is completely new. So we are not focusing for some particular areas, and everything is of interest for us. So market operators, please communicate with us. Please communicate with the Ministry of Agriculture, which is the policymaker in the case of this law, and tell everything what you come across in application of this law. So this is my words as the representative of the Competition Council, and yeah, this is it. Thank you very much.
Thank you. Katrin, what are your kind of concluding remarks on this new topic?
Yes, thank you. I think the first thing that we should do in Estonia is to prepare a new section in our website where we can put all the unfair trading practices, questions and answers. And then the undertakings can take a look of them, and then it's much more easier for them to probably to operate. And then we will see what we will do.
I think that would be very helpful to have the Q&A on the web page and the introduction. Udis, maybe Latvia, then Lithuania for the last, and then I will conclude the webinar.
Thank you, Elo. What my impression from the guidance issued by the Latvian authority and some of the other European authorities, and also European Commission, who is the author of that directive, is that quite a few unresolved issues remain, and they will have to be addressed by the courts. And I think it is inevitable that this will happen. One thing that we have not mentioned this far, but which is very important to keep in mind, is that at least in Latvia and several other member states, the implementing provisions can be applied without the competition authorities being involved, that is to say, in national courts. So bear in mind that you can be a respondent in proceedings based on the new law, or when confronted with a claim, you can use probably the new provisions as a shield, as a defendant. That is also a very important aspect of these new private law, very specific, but private law rules. Thank you.
Asa, what are your concluding remarks? Lithuania for me, has always been the most notorious authority with the most enforcement, and we see it from the past. And do you see also it coming and going forward with a lot of enforcement?
Well, it's a very good question, actually, as we have currently even two authorities to cover this UTP directive. Competition Council and the Rural Market Development Agency. So I think double forces would not leave the suppliers and the buyers bored. And by saying suppliers, I just want to stress again that it's a good tool to protect the suppliers from the unfair trade, but the suppliers should not forget that they should be they could be in the buyer's position as well when they buy the products in the supply chain. So let's not forget that, which sometimes is forgotten, at least in Lithuania, when we speak with such clients, as they treat them as the suppliers as it was before the new law was implemented. So, and having in mind the new procedural powers from both the authorities, including to do the downgrades in the companies, which was a common practice in the cartel cases and other antitrust cases, I think the compliance is becoming more and more important to all the businesses acting in all three Baltic states. Because one short note, in Lithuania, according to the new Lithuanian law, the supplier may choose where to initiate or to apply with the infringement application. It can happen both in Lithuania or in the country where the buyer is established. So there are more choices.
It is true. Thank you all so much. Maybe a few words for Estonia, also concluding remarks. Well, it is new for us. So there is still transposition deadline for the existing agreements. The new agreements would need to follow the new law, I would expect already earlier. So going forward, there is a lot to look at, and of course, to some ways we can rely a little bit on Latvian and Lithuanian practices, but I hope not too much, because Estonian regime is a little bit less strict. It is quite strict with regard to that everybody is covered, no turnover thresholds. But at the same time, the lists of unfair practices are a little bit shorter. From the unfair practices list, I would just remind everybody that the conditional grey list item transport packages is something which is unique for Estonia. so the suppliers can refuse the retailer's request for the transport packaging. Not sure how it does well with the efficiency or logistical efficiency, but I guess unfair trade practices are here to regulate the fairness of the chain as well, not just efficiencies. So with this, I would really like to thank so much our speakers. I would like to thank Latvian Competition Council Svetlana Sintikova and Cynthia Nagle for talking us through the Latvian rules. I'm really happy that Katrin Tasa has joined us, jumped into the water, the new rules, and something that hasn't been here, but ready to offer the comments and then the thoughts that more information will come on the Competition Authority webpage is really welcomed, I believe, by the market participants. And as always, Udis and Rasa, it's wonderful to do webinars, work and have fun together with you. So it's great to have this webinar together. And I believe that this is not the end of the story, but just the beginning. So we hope very much that you have had a little bit of insight to it and can see it a bit more like on a broader view. So thank you very much, everybody. Have a very safe time. Stay warm and happy. Thank you.
Thank you. Goodbye.